Good afternoon, esteemed guests, distinguished speakers, and participants. It's my great pleasure to welcome you to this side session on AI and intellectual property protecting innovations. Today, we delve into the dynamic intersection of AI and IP, addressing critical questions and exploring the forefront of innovation and legal thought in this domain. Today's session is a critical dialogue on how legal frameworks can evolve to meet the needs of AI-driven changes in production and service distribution. We will explore the complexities of intellectual property in the realm of AI, considering how to protect and monetize AI innovations, secure datasets, and navigate the landscape of IPR across various jurisdictions. As we move forward, let us collectively engage with the dynamic conversation which will inform and refine our strategies in the ever-changing realm of AI and IP. I would now like to invite our keynote speaker and esteemed panelists onto the stage. Please join me in welcoming them with a warm round of applause. Honorable Ms. Justice Pratibha Singh, Judge, Delhi High Court. Mr. Rahul Mathan, Partner, Trilegal. Mr. Praveen Anand, Managing Partner, Anand & Anand. Mr. Abhishek Malhotra, Managing Partner, TMT Law. Ms. Napinai, Advocate at Supreme Court, Founder, Cybersathi. It is my honor to introduce Justice Pratibha M. Singh, an authority in the field of intellectual property law in India. A scholar from Bangalore University and the University of Cambridge, Justice Singh was the first IP practitioner to be designated as a senior advocate in India. Her judicial appointment in 2017 marked the continuation of an illustrious career, during which she has been instrumental in framing India's national IPR policy. As a respected member of the judiciary, she now leads the Intellectual Property Division and has been recognized internationally, including being elected as an honorary fellow of Hughes Hall, University of Cambridge. Madam, we respectfully invite you to commence the keynote address.
Very good afternoon to all of you. Delegates and dignitaries on the dais, off the dais, ladies and gentlemen. It's my pleasure to be here. I can tell you how difficult it is to leave in the middle of the day from court. But I thought that this is a forum where the intersection between AI and IP needs to be spoken about. And I must confess before I start my presentation that my knowledge of AI would be very little compared to the least experienced in the room as well. So I'm going to bank on my knowledge of IP to be able to speak about AI and IP today. You all would be far ahead in understanding how AI works, and AI will shape the future. But from the concept and from the perspective of IP, I'm going to present the next few slides to you and leave it to you for the discussions going forward. I'm not sure of these statistics, but these are statistics which are available on the net. As they say, statistics are statistics. So the expectation is by next year that the AI market would be about $191 billion. And that proves why each of you all is sitting in this room, and why we are discussing it with such seriousness. So in India, as you can see, there is an expectation that there will be almost 100% increase year on year in AI, and it would reach $665 million at some point. And these are projections which are given. The Niti Aayog's projection is that in the next 8 years, AI would have the potential to add $1 trillion to the Indian economy. I just hope this is true, and India does get there on AI. There are various goals which are mentioned by the government in its artificial intelligence mission. I don't need to emphasize it because I'm sure this is being circulated everywhere. Let's come to AI and IP. When I thought about it as to what could be the intersection of AI and IP, there are three broad categories that come to my mind. The first is, of course, the million-dollar question as to whether AI can be an intellectual property owner at all, of any intellectual property which is created by AI. There are a few examples which I'm going to show you. And it could be whether brands created by AI, copyrighted works created by AI, innovations made by AI, patent applications filed by AI, designs created by AI. We know that a large number of molecules which are now churned out of the computers, which go in for clinical trials, are all AI-generated molecules. So, can AI be an inventor by itself? Can AI be an inventor maybe with a human being? Or can an AI not be an inventor at all? That's the first question that comes to my mind. I'm going to just use a few examples and give you my perspective. The second is, of course, AI as a tool and a catalyst for innovation. This, I think, is a very distinct and a realistic possibility, because by using AI, just like we use a Microsoft Word or a PowerPoint or any other software or any other gadget, we could use AI as a tool, and the human mind could generate and innovate more. And I don't think that that can be a problem at all. In the last segment, I want to speak about how AI can also be an assistant in IP management, IP maintenance, IP enforcement, and IP protection. So these are the broad areas where I think that AI and IP have a clear intersection. And everything that AI is doing today would fall in one of these segments, in my view. And therefore, let's discuss it and see where it goes. AI as an intellectual property owner. Can inventions from AI algorithms, techniques, or processes be patented? Or do we need a sui generis right for AI inventions? I don't know. It's a question mark. Can AI-generated works such as art, literature, creative works, and source code be copyrighted? Trademarks are vital for AI developers looking to establish and protecting their brands. Can AI promote these marks? We all know about DABUS, the AI-generated innovation, which was an AI system. And this case actually proves how the law is actually grappling with it, in my view. Because you will see the different views taken in different jurisdictions and reversal of views in the same jurisdiction as well, when you look at DABUS. So DABUS was used to create 2 new novel products. I don't think anyone is discussing about DABUS here. This is about the patentability of this. In India, objections were raised at the stage of the examination, and it was not recognized as a person. But there is also a pre-grant opposition which is pending. So right now, it is still in the realm of, most probably, the patent may not be granted. Let's look at Australia. You'll be surprised that in Australia, the patent office actually granted the patent for DABUS. But the Court of Appeal rejected it, and the leave to approach the Supreme Court has also been rejected. So now, Australia took a different view on DABUS, which was a pure AI system. So the Court of Appeal said AI system cannot be named as an inventor of a patent under current Australian law. So that was the clear categorical finding of the Court of Appeal. Let's look at US. Thaler versus Vidal. Again, the Federal Circuit Court said under the Patent Act, an AI software system cannot be listed as an inventor on a patent application. So this is clear. Same in the United Kingdom. South Africa granted it, but as you all know, South Africa doesn't go through an examination process at all. It's just like you file and you get it. Everything happens later. Now, this is the situation insofar as one AI system was concerned under the existing patent regimes across the world. What about India? Are we happy with the position in India? Do we need to look at a new thinking in India? One of the biggest provisions in Indian law, which kind of meddles with AI, is Section 3K. As on today, the law as we speak on Section 3K is that unless and until a computer software program per se is not patentable at all in India. And I recall very clearly the bill which was introduced in Parliament at the time when this statute was being contemplated, Section 3K was being contemplated. A number of experts had made presentations, and unlike, the bill, in the bill it was an absolute bar, computer program. The words per se were not there in the bill. It was because of various presentations and stakeholders who gave their views, thinking that even at that time the Indian software industry was quite a leader. So then the European position on computer programs as such was considered, and then the Indian legislature added the words per se with computer programs. So the word per se having been added, the question arises every day in court, even when I'm in the IP division, where patents have been rejected for computer programs. The law now appears to be settled that US is was slightly different, but then after the recent judgments like Alice, etc., I think Alice, and in Europe we have a large number of judgments. The law that has now come out globally is that if there is a technical effect of the software, you don't need a customized hardware for the program to be patented. It can even happen on a general purpose hardware, but if there is a technical effect or a technical advancement, a patent can be granted. But now the question is that enough in the context of AI? Would that be sufficient? So recently there was a decision of the Delhi High Court called Open TV, where the view that has been expressed is that there needs to be a relook on Section 3K, because the need to consider the march of technology in the digital space is an urgent one, so that patent law is not outpaced and patenting itself does not become irrelevant in the years to come. Because if we don't change the law or do a rethinking, patenting will become irrelevant, because AI will change every year, literally. I mean, we won't be having any patents on these kind of technologies then. Let's look at copyright now. This is a painting called Suryast, and this was created by a AI author called Raghav. It was filed by a human being, obviously, but the question is whether this painting deserved a copyright. The copyright registry initially granted copyright to the painting, but then it was withdrawn, stating that Raghav could not be an artist under the Copyright Act, and with Raghav being the sole author, the copyright cannot be granted. That's the view that the Copyright Office has taken. As we are debating and discussing it, Europe has taken the lead and has come out with the European Union AI Act 2023. I'm sure all of you are very, very well aware of this. I don't need to dwell on it much. Let's look at what the WIPO is doing. And the question is whether one of the documents of the WIPO states that if you don't grant patent protection to AI, we may go back to the trade secret position in the world. Is that good? Is it bad? Because the whole concept of patents was you disclose and you get a quid pro quo protection. But if you're going to go back into trade secrets, then that could be a problem for growth of technology. And would it be a ground for patent revocation if a human were wrongly named as an inventor of an AI-generated invention? What would happen in that case? So within the office, an invention could be created by an AI, but the person operating the computer could then say, I'm the inventor. So how would we inquire into all that? So the question is how to go about AI. As the focus aspects of the WIPO is that at the moment AI can be used for assistance, better research, and even for patent protection. However, AI cannot be characterized as an inventor. But will this help or will this stop research and development? That's the moot question. In my own view, if you see some of the patents which are now being granted, for example, a AI for vocalization and producing music using AI for creating content on display devices. So AI as an assistant to innovation, patents are being granted, if you take a look at these inventions. So if it is a collaborative effort of human and AI, patents can be granted. That's the position as on today. But of course, AI can be used as a tool for enhancing innovation. There's so many advantages of AI which I don't need to dwell on. I mean, these are all things that you all know and debate on a day-to-day basis. Now, coming to the third segment of AI as an IP assistant, I feel that it will be very useful to take the assistance of AI systems for conducting patent, trademark, copyright searches, case law searches for propositions, comparative law analysis, even predictive analysis. I'm quite sure if we use an AI program to analyze the decisions coming from the IP division of the Delhi High Court, you'll find so many results being thrown up. And that could just help us to see as to whether we are going on the right path and what is the kind of vision we should have. Valuation of IP. Currently, we don't have anything to value IP. I mean, I remember in the company court, there was a brand, a very well-known brand, was one of the assets which was in liquidation, and the OL came up with a report saying that the brand has been valued by the CA at 5 lakhs. My jaw dropped. I said, this is not possible because this brand is so well known. It had to have a much higher value. So there is no, I mean, there's no methodology, software. You only have some accountant sitting in a room and creating reports for valuation. I think we need to have a broad-based IP valuation software which will help small, medium, and big businesses to value their IP, reflect it on their balance sheets, maybe use it to raise funds, to get loans, I don't know. IP valuation is one major area where I think AI will be very useful. So we could also use AI tools for doing novelty searches. There are some which are already existing. And of course, we have the case of Christian Louboutin, where AI answer was cited by the council. And it was interesting to see how when we put the same question in the chat GPT, it generated 2 or 3 different answers in a gap of 2-3 hours. So different answers came up. And so the view of the court was that accuracy and reliability of AI-generated data is still in the gray area. AI cannot substitute human intelligence or the humane element in adjudicatory processes. At best, the tool can be used for a preliminary understanding. There's one issue on AI which I would like to flag here. Of course, the bias of the data. And secondly, most of the AIs that are currently available use data from the developed world which is already fed into their systems. Data from this part of the world is not there in their databases. So the results that come out of big, large language modules, all these LLMs, etc., could be a little skewed. So we need to be very careful about biases. You know, there are issues like, I remember the police software in the US which was used. So we need to be very careful before we kind of use AI as a final thing. It could definitely be used for research. So I was of the opinion that AI at this stage can only be used as a tool. But I must say, there's been an English judge called Justice Colin Burrs from the UK Court of Appeal who used AI ChatGPT to write some portions of his judgment, and he admitted it openly that I did use ChatGPT, and I stand by whatever is there in that because I have read it and I verified it, and so be it. So there are 2 different views which are there. Now, can AI replace lawyers and judges? At least for now, they can't. So all our jobs are secure. So let's see how it goes. AI-generated content and content creation. You know, in the US, there was a very serious case where the ChatGPT created a whole brief which got filed in court, and all the precedents in that were fake. All the precedents. So can you imagine doing this in a court of law here? I wouldn't imagine. We shouldn't be doing it. And this would be very dangerous, in my view. So there are ownership issues in AI, licensing components. How would you, license it? How will the royalties flow when there's an AI-generated, patent or a copyright or IP? So these are the issues I think that needs to be addressed at the global level. I think I had my time of 10 or 15 minutes, which I'm running out of. So I'll come to the last slide. I think that there is time for a dynamic legislation which needs to be brought out. The problem here is, as I see it, legislation as it is coming is getting outdated very quickly. For example, the biggest example is the data protection bill in India. By the time it came, there was a committee report, the report came, they made amendments, and then by the time it could be introduced in parliament, I'm sure they felt that it was outdated because so much had happened in 2 years that the old law could not be applicable anymore. I think the same thing is happening even with the intermediary guidelines. The law is changing almost on a daily basis. As all of you who watched Oppenheimer, he used the sentence, I became death, technology versus arms. So I don't know. I don't think it is so bleak, but I just wanted to have it there. I just think it's a hare and tortoise race. The law is trying to catch up with technology. For those of you who've read the Dan Brown book called Origin, I think it's at least 10 years old, if I'm not wrong. That was an AI generated, catastrophe. But then ultimately the divine power saves the world. That's all that I would like to say today. Thank you for listening to me, Krishna.
Thank you, ma'am, for the insightful speech and the valuable knowledge that you have shared with us. In the interest of time, I would like to request CEO Sir Mr. Abhishek Singh to kindly felicitate Justice ma'am. We are now privileged to have a virtual keynote address from Professor Nick Bostrom, an eminent professor at the University of Oxford, known for his expertise in applied ethics. Professor Bostrom's insight into the ethical and intellectual aspects of AI and IP are highly anticipated. As he joins us remotely, let's welcome his thought-provoking perspective on these crucial topics.
The field of artificial intelligence is extremely fast-moving, and I think it will have a transformative impact across almost all sectors of human society in the coming years. I want to make a few remarks on AI relation to patent law and intellectual property, pointing to two particular areas of challenge, and then make a general suggestion for one way that one can maybe approach these challenges. So first, on patents, the criteria for patentability, in particular novelty, non-obviousness, and human origination or participation, each of these really is a matter of degree. Fundamentally, it's a question of creativity, and creativity certainly comes in degrees. Current AI systems already exhibit significant degrees of creativity. We see this with large language models, with image generating models, and also with more specific domain focused AIs that can be applied to biomedical discovery and in other fields. And the degree to which AI systems are able to be creative will be increasing over the coming years. So this means that criteria that are all or nothing, where there is a semi-arbitrary threshold drawn, will, I think, come under strain. It will be maybe more natural to think in terms of degrees of patentability rather than it being an all or nothing question. You could imagine patents that cost different amounts to apply for, that have different scope, different duration, or maybe some patents that require an active investment to develop and deploy the idea as opposed to just registering the claim. Another effect that I think we will see is that once AI systems reach some threshold of capability, they might very quickly be able to make a huge number of discoveries in a particular field, to canvas an entire domain, and not just make 2 or 3 or 10 or 20 discoveries, but perhaps millions of discoveries within the course of a couple of weeks. So you could imagine some extension of the AlphaFold system that DeepMind developed that predicts how peptide sequences fold into 3-dimensional protein structures, but for designing protein structures. And if you then have a big database of molecular targets, you could, once you have built this AI, very quickly then, find perhaps millions of different specific design for potential drug molecules, etc. And so when you have this ability that whoever first reaches the requisite level of AI capability can almost immediately canvas a whole field, and anybody who comes in after maybe develops an equally good AI 6 months or a year after, just find the whole field already exhausted and all the discoveries already made. There is a question of how to think about the patent system and the incentives they create in these contexts where you might have a very strong winner-take-all effect. On the issue of intellectual property, I think we will see a challenge in terms of current large models that are trained on vast amounts of data. Now, certainly it seems fair that creators of content should at the minimum have the rights to opt out from having their content used in future training rounds. But that might not be sufficient for preventing these systems from outputting infringing content. I think there will be increasing use made of synthetic data to train these models. And it might well be that synthetic data combined with data that is in the public domain will be sufficient to produce outputs that are too similar to copyrighted materials to be infringing. So even if you prevent sort of copyrighted material from going into the training process, you might still get outputs out that could be infringing. It could be too similar to a particular existing picture, or maybe too similar to some existing person. If you develop an AI model trained on public appearances of some particular person or things they have said that is in the public domain, but then train a model that is able to too closely emulate the particular person, that might also perhaps be regarded as something where each person, as it were, have a copyright on their own mind and where there could be an infringement. One possible approach here might be to use AI tools as part of how we police copyright infringements. So you could imagine an AI that generates, say, images, and then another AI that checks whether the output of this model is too close to copyrighted material. This could either be developed by the AI company itself that provides the image generating model, or you could imagine some publicly funded model that would make it possible for holders of intellectual property to more easily check whether there is anything out in the public domain that might infringe their copyright. So I think increasingly it will be necessary to use AI tools as part of the solution for how we monitor whether intellectual property has been infringed. Now, I should stress that this is a very fast-moving field, and I don't think it's feasible today to come up with a complete and final solution to how to deal with this. This will be something that will require ongoing attention and continuous adjustment, and keeping close tabs on how the field develops, and then try to come up with some sort of sensible responses around that. And with that, I'll leave it for you to figure out how to do all of these things. Thank you.
We will now move forward to the second segment of our side session, which is a moderated panel discussion. This panel aims to thoroughly examine and address the intricate relationship and challenges found at the convergence of AI and IP. Moderated by Mr. Rahul Mathan, this panel will feature various experts, including Mr. Praveen Anand. I request you, sir, to kindly come up on stage. Mr. Abhishek Malhotra, Ms. Napinai, Dr. Maha, we will please know that we also have pre-recorded messages from our other speakers. Ms. Katya Lane, she's the founder of Talker AI. She's also an expert on innovation and commercialization working group GPAI. Mr. Barry Scannell, consultant William Fry LLP, and Dr. Meera T. Sundarajan, who is a visiting professor at UC Davis Law School. Over to you, sir.
Thank you. What a wonderful time to be alive. I'm not acting cool. These are the latest Meta Ray-Ban glasses. It has a camera, which means I can just take a photograph. You see the light flash? But actually more than this, you didn't see the light flash. See, this is a privacy violation. You should have seen the light flash. But more than this, what I can do is, hey Meta, and it will automatically record a video of you. It sends this to my phone, and it automatically puts together a lovely little montage entirely by the AI. So AI shoots the video, AI then puts it together into a movie, and Justice Singh just said that AI is going to be our assistant. I worry whether I am AI's assistant in this process. Because essentially, what am I doing other than carrying around a camera for the AI to make a movie on? This is the world that we're in. And in this world, I wonder whether our existing laws of intellectual property have fully understood what it is going to face. We have a wonderful panel today. I think the timing couldn't have been better. The EU government came to an agreement on the AI Act. Even though the AI Act has got many elements, we have speakers from around the world and in India who will cover a number of relevant issues with regard to how it will have an impact on us. And I want to call up first our speakers who've recorded video messages. Katya, who will actually give us a sort of a broad overview of how the AI Act now impinges on the way we're thinking about AI.
Addressing you on the pivotal intersection of artificial intelligence and intellectual property at this summit. Today I bring together insights from the two key perspectives to shed light on the evolving discourse surrounding AI, copyright, and the regulatory landscape. I would like to start with a listing of ethical considerations for granting moral rights to AI-generated works in comparison to human-created works. Authorship, attribution, and accountability define clear guidelines for human involvement in the AI-generated creative process to maintain accountability. Respecting cultural and social values. Consider the cultural and societal impacts of AI-generated works, prioritizing ethical standards and avoiding harmful content. Informed consent and user awareness. Emphasize the importance of informed consent and user awareness regarding the AI role in the creative process. Dynamic nature of AI systems is important also. Acknowledge the dynamic nature of AI systems requiring flexible and adaptable ethical guidelines. And the last one is balancing AI autonomy and human values. Seek a balance between the autonomy of AI systems and human values to ensure ethical AI creations. These considerations are bound to find an appropriate place in the regulatory framework. My first point today is about the regulatory landscape and copyright dilemma. The European Union has just adopted the AI Act as landmark development in a field of regulation and artificial intelligence. A new era is opening up for AI manufacturers, users, businesses, and society. Some stakeholders express concerns about its potential implications for intellectual property, particularly copyright. The AI commendable risk-based approach aims to ensure the safety and trustworthiness of AI systems, primarily those categorized as high risk. However, as expressed by industry professionals, worries exist about the adequacy of this regulatory framework in addressing the intricate relationship between AI and copyright. The complexity of this issue extends across legal, economic, and societal dimensions, necessitating an expert-driven dialogue among rights holders, AI professionals, researchers, citizens, and other stakeholders. My second point is about balancing innovation and culture. On one side of this multi-phase debate lies the call for careful consideration before rushing into regulations. The recent amendment to AI's copyright directive in 2019 showcased a responsible legal system, introducing the right of opposition for rights holders in light of technological advancement, including algorithm training. This underscores the effectiveness of existing frameworks, advocating for a prudent approach to allow established regulations to produce their intended effects. Acknowledging the symbiotic relationship between AI and creativity, we, as digital stakeholders, extend an invitation to the cultural sphere, governmental bodies, and AI actors to collaboratively explore and build consensus together. And my third point is about the interplay of AI, copyright, and datasets. In the ongoing efforts to regulate AI, the question of copyright within training datasets surfaces as a crucial yet often overlooked aspect. The ownership and usage rights of data used to train AI models must be carefully examined, presenting an additional layer of complexity of the broader discussion. As we traverse this uncharted territory, the implication of AI innovation, especially in generative AI, demand careful consideration. The European AI Act risk-based approach is deemed pertinent, but concerns linger about its suitability for addressing the nuanced relationship between AI and copyright. In conclusion, the key words are quality and accessibility of data for AI actors. While we navigate the complexity of AI and intellectual property, let us not lose sight of a critical factor for the actors in the landscape: the quality and accessibility of data. The success of AI innovation hinges in the availability of diverse high-quality datasets, striking a balance between protecting intellectual property and fostering innovation requires not only thoughtful regulation, but also a commitment to ensuring equitable access to data. As we move forward, let us collectively work towards a regulatory framework that encourages innovation, safeguards intellectual property, and promotes the responsible use of AI. Thank you very much, and have a nice summit.
I'd now like to do the video from Mira. Mira, I think, is a professor in Stanford, but she actually takes some of this video and goes into a little more detail, which is what are the implications of the concept of moral rights on regulating intellectual property in AI.
Greetings from San Francisco, California. I am Meera T. Sundararajan, and it gives me great pleasure to have this opportunity to address the meeting today. Thank you very much to the organizers for inviting me. I would like to pull up a few slides to accompany this brief presentation. And as I'm introducing myself, I'd like to say that it is especially gratifying to be able to speak to you in India in the week of December 11th, which is a historically and culturally important day. This year, December 11th was the 141st birth anniversary of Indian national poet and Tamil Mahakavi, C. Subramaniam Bharati, who is pictured here on this slide and who will, I think, be familiar to many members of the audience. C. Subramaniam Bharati is also my great-grandfather, so thank you very much once again. In my brief remarks today, I'd like to focus on moral rights, an area of intellectual property regulation that sometimes flies under the radar in the IP community. But in the era of technological advancement, moral rights are extremely important. And in fact, with recent developments in artificial intelligence technologies, I would suggest that moral rights have become more important than ever before. They are absolutely essential as an instrument of policy for us today. In the very recently adopted European Union Act on Artificial Intelligence, there is a core concept, the concept of transparency. And in fact, transparency closely resembles the doctrine of moral rights of authors under copyright law. In fact, you could even say that it's another form of moral rights. Moral rights can help us in two ways in the era of artificial intelligence. They can be a tool of effective copyright regulation and a tool helping us to modernize copyright in the AI environment. They can also serve as an invaluable template for effective approaches to AI regulation overall, as in the example of the EU AI Act. Policymakers, I would suggest, should explore foundational concepts such as disclosure or consent, attribution or credit, and integrity, drawn from the doctrine of moral rights of the author for the benefit of artificial intelligence regulation. The moral rights that are protected, what do they involve? The right of disclosure is the author's right to publish a work or to keep that work private. It is the author's right to be credited, attributed as the creator of their own work. It is the author's right to protect the integrity of the work, to prevent it from being harmed, mutilated, or destroyed. Moral rights are personal to the creator. They're inalienable, and potentially they can be protected in perpetuity. They're fundamental to copyright laws everywhere. Notably in India, under Section 57 of the Indian Copyright Act, moral rights receive extensive and sophisticated protection. In Europe, all European countries recognize extended schemes for moral rights protection, and France and Germany can both lay claim to being the country of origin, the culture of origin of the moral rights of authors. The purpose of moral rights is to protect our fundamental human rights, rights arising directly out of our human creativity. Moral rights and copyright, it is worth remembering, are both protected in international human rights instruments as well as copyright laws. But there's also a public interest rationale behind moral rights, which we must always keep in focus, that the goal of moral rights is to protect the cultural heritage that ultimately belongs to the public. Attribution and integrity rights protect historical truth. They protect facts and the integrity of all kinds of works embodying valuable human knowledge. Transparency, as I've said, is the core effective concept of regulation underlying the EU AI Act, and it is a concept that brings moral rights immediately to mind. The EU Artificial Intelligence Act is a risk-based approach seeking to protect members of the public from high-risk AI that can expose them to new kinds of vulnerabilities. What are the policy concerns that EU regulators have faced in this area? First of all, they have become concerned about the deception of the public and the accompanying degradation of knowledge, information, and culture due to the proliferation of false information, as well as the corruption of true information, all of which has incalculable social, educational, and political consequences. And the EU is also concerned about the abuse of fundamental human rights, which can occur by manipulating emotions or human identity through biometric features, neither of which, by the way, are possessed by machines. In this environment, moral rights can play a key role. Thank you very much for your attention to these brief comments. I hope you will find them interesting and intriguing, and I hope to have the opportunity to speak to you more about them in the future.
And finally, Barry, who takes us on a, just like Justice Pratibha Singh took us on a whirlwind tour of how AI will impact IP. He also does sort of a whirlwind tour of a bunch of countries and how they're looking at AI and IP.
Hello everybody, my name is Barry Scannell. I'm a solicitor in William Fry, based in Dublin in Ireland. I specialise in artificial intelligence law. I'm a member of Ireland's AI Advisory Council, and I'm delighted to be able to speak to you today and absolutely heartbroken that I'm not able to be there with you in person in New Delhi. I'm going to talk briefly about AI outputs. So when I talk about AI outputs, I mean AI creations. And in particular, I'm going to talk about the copyright aspects of AI creations. So it's an open question whether or not anything created by an AI is actually protected by copyright. If you look at Europe and individual member states within the European Union, the likes of France, the likes of Italy, copyright protects works of the mind. So it's very anthropocentric, human-centered types of copyright. Ireland, however, is something of an outlier, as is the UK. Of course, Ireland is still within the EU, and Ireland's copyright legislation says that where a work has no human author and it was created by a computer, then the author of that work is considered to be the person who made the necessary arrangements for the creation of the work. So that allows for, computer-generated authorship. But that's so far outside the European copyright law that if it was ever tested, it may not actually be successful in the CJEU. Now, in the United States, it's quite interesting, because in the United States, they have a system of copyright registration, which most places don't have. So to be able to enforce your copyrights, you need to have a copyright registration. And as a result, the US has started looking at these issues before anybody else has, with some interesting results for the rest of us to consider. So at the outset, it's important to point out that in the US, they're very explicit that only a human can be an author. So they actually go into examples. Taking a selfie cannot be an author. They give an example that a divine being and a Holy Spirit cannot be an author. So it's very explicit, only a human can be an author. So last year, an author called Chris Castanova tried to copyright a graphic novel, comic book called Zarya of the Dawn. And initially she was granted protection, but then the Copyright Office called her back when they discovered that the images within the graphic novel were created by the AI Midjourney, which is an image creation system. So ultimately the Copyright Office said to Chris Castanova, the text you created, that's absolutely fine, that's protected by copyright, you created it. The actual graphic novel itself, that's fine, it's protected by copyright because you made the arrangements between the words and the pictures and so on. But in terms of the individual images within, those were not protected by copyright. So the ultimate effect of that is that those are public domain. So this means that even though you can have something in the round that's protected by copyright. Individual components of it that were created by AI may not be protected by copyright. And then later there was a court case in the district court in the United States at a federal level involving Stephen Thaler and a piece of art called Another Entrance to Paradise. And he was arguing that he should be able to register the AI as the owner of the copyright. But that court reaffirmed what the Copyright Office was saying and reaffirmed the US approach to copyright and said only a human can be an author. And AI systems that create works, those works are not protected by copyright. So the current status quo, at least in the United States at a federal level, now look, I'm sure it's going to go all the way to the Supreme Court there, and it remains to be seen what will be the ultimate decision made. But for now, the default is that you have to be very careful about such works, particularly in the US, because there's an open question around whether or not they may be protected by copyright. Now you might be thinking, well, I'm not a creator, I'm not creating pictures or photos or music. Well, what if you're creating software? Everybody creating code at the moment is using AI. And if you have code in a piece of software, the piece of software might be protected by copyright, but individual elements of code may not be. So when you consider your contracts that have provisions around copyright assignment, be it with employees, be it with contractors, you can't assign something that doesn't exist. So how do you protect your copyright? Well, one of the ways is with trade secrets, and make it a trade secret which elements of your software are created by AI, in which case it would make it very difficult to discern which lines of code you're able to actually take out because they're public domain. So it's a brave new world in terms of how do we protect copyright, and there's a lot of unanswered questions. But I'm really looking forward, and I'm sure you're going to hear wonderful ideas around it throughout the conference. And I really hope that you enjoy the rest of it. Thanks very much.
So really provocative questions right at the end there. If we have AI Copilot generating code, then we can't actually transfer or assign the license or license that code. I want to now turn to the panelists here on stage and have a sort of a quick moderated discussion. We don't have an awful lot of time, but I want to just start with Maya on the just this question of generative AI and the implications to clearly copyright. But I'm sure at some point in time we'll get implications to patents as well. I've been writing a weekly column for since 2016, and last year this time I wrote an article that I used AI for. In fact, the entire article was written by AI except the last paragraph where I said everything that you've read above has been written by an artificial intelligence. Of the book that I came out with a little while back, even I don't know how much of that book was generated by AI. I have told the publishers that I have copyright over it. But this is the world that we're in, that AI is actually capable of generating content that is in many ways indistinguishable from human. And we have this requirement under intellectual property law for there to be the human element in it. What is that human element? And I also want you to think about the question that I think Justice Pratibha Singh raised, which is we're introducing into these AI models source material, raw material that was created by humans. And sometimes the output of these models tend to look very much like as if a human had done it, as if Van Gogh had painted it. How do we think about questions of copying, because it's not really copying? How do we think about questions of ownership and attribution? How do we think about revenue sharing? There's a vast canvas. Pick whatever you can of it, and your comments.
So thank you very much for the opportunity to speak here, and also thank you very much for pronouncing my name right. It's Maya, true, with all the meanings, the good meanings that came on your mind. So copyright meets AI, especially generative AI, in 4 points. First point is algorithm that is trained on data. Algorithm as such is protected by copyright. That's one relatively easy thing. The second point of when generative AI meets copyright is when we ask ourselves exactly this question. AI today is an algorithm trained on data, and then it becomes super clever, like a little child thrown into the world and then trained on experience, and then it becomes clever. The big data that the algorithm is trained on can be personal data, co-generated data, and in some part it can be content protected by copyright. And that's really pressing question. Is this that the machines train on data in any case copyright relevant? Professor Mira was mentioning moral rights. She was saying, as I understood copyright expert, it's extremely relevant. But well, first we need to understand whether when machines train on the content, is this really copyright relevant act? Is it more like reading? So US courts are answering these questions right now. In Japan, they say it has nothing to do with copyright. It's allowed. In Europe, we have system of 2 exceptions for research and for others. And so this is question that will be answered probably by US court. And it's pressing. I personally think that copyright is not there to cash out every single use. Maybe machines just read and learn. Maybe machines do not copy, and that's why they need to pay to copyright holders. In Europe, we have very good system of 2 exceptions. I'm available to go deeper for everyone who is interested into this question. So this question, whether when machines are trained on data and that data may be protected by its content, by copyright, it's the second thing that it's relevant. The third thing is when generative AI spits out results as that column that it spitted out for you, whether the authors that offered, well, not offered, when machine was trained on this data, when those right holders has any interest in that column as well. It's question of derivative work, even more difficult. More difficult question probably if your column would be very, very similar to another column of another author, maybe the answer would be more straightforward. But of course, you open another question with it, which is not a copyright, plagiarism. Is it fair that you say, I did this great column, it is absolutely necessary to behave like you did, to be transparent, and you said, I use this great tool. It's important also to tell the students in school, you need to learn how to use this technology, but you need to be transparent that you're using the technology. But let's leave this as a side. The final thing is, question, when AI will be sentient, when it will have conscience, when it will have personality, and today it doesn't have. Today is just a powerful tool. When in this case, whether AI will be granted copyright protection or not. So far, it's no in many jurisdictions. In Chinese court this year said yes. So but otherwise in European legislation, in US doctrine, the physical person, the human needs to be created. And I will finish now. To do good AI, we need good data. And it's also important to explain to people that we need good data for good AI. And if people will understand, then also many barriers to adopt AI will be easier to overreach. So although copyright is an extremely powerful tool, it should not put AI on its knees, but we need to take it in consideration. Entertainment industry should not control the production of AI. That's very important to say here as well. We should recognize in justified cases moral rights and or IP. But the final point is IP, copyright, is not meant to be there for itself. It's here to support the progress of society. So we need to see what we want to achieve, and then we want to balance the IP system to achieve that goal. So we should not worry whether IP laws are okay with AI. We should worry whether IP laws are okay for society to achieve the goals that we want. Thank you.
And Napan, I'm going to come to you in a bit, but I just want to ask you Maya, just one redirect and make the answer really quick. I think generative AI and art. So if Midjourney generates an image in the style of Van Gogh, I don't really care. Van Gogh is dead. He's not going to claim copyright. But there are young, struggling artists whose work is now ingested into AI, and AI is generating images in the style of those artists. And if we think that the purpose of intellectual property is to encourage creativity and innovation, if generative AI image software starts to make it very easy for me to copy a young existing artist's work, how do we deal with it? What is the thinking that we need to put into reimagining intellectual property protection?
For a machine to be so clever, to be capable to do something like that, it ingested millions and millions and billions of works, not just the work of young artists, also different kind of artists. And it's what really one work means, and it's always important, but we need to go back to the question, is it really copyright relevant act? If you ask copyright lawyers, they will probably say no. If you ask philosophers, general public, it will say, well, it copies something, so we need to give them some sort of rights. These questions are really, really important, but should need to be addressed not by the feeling in the stomach, but with the deep understanding of copyright law, why we have it and what it needs to promote. So, very challenging time. It's exciting to be copyright expert, but as a society, it's really challenging to offer the questions that will make AI work for common good, not just for particular companies and corporations or governments.
So of course, when we talk about images being generated, we have to then move to videos being generated, and that takes us straight into deepfake territory, particularly since we're getting into election time around the world. And this, of course, doesn't. The first thing you think about is not really the intellectual property side of it. You think about people being fooled and those sorts of things. But some time back, there was a Star Wars movie that was shot after Carrie Fisher died. And I was really happy to see that AI had generated a deep fake of Princess Leia, and she could actually come in the movie. So I wonder whether this is such a bad thing or is it a good thing. Bruce Willis, currently, legend of a film star, is now suffering from dementia and he will never be able to act again. And I wonder whether if we could actually use AI to generate not a deep fake, not a fake, perhaps a permitted image of Bruce Willis, whether we could continue to watch Die Hard, I don't know, 21 or whatever when it happens. So I'd like to turn to you to just reflect on some of those things.
Absolutely, because Rahul, deep fakes have been tarred and feathered, right? So it's really important for us to look at it from a very different perspective. So I'm going to rely on two provocative propositions in my intervention today. And I'm going to focus primarily on a subset of deepfakes also, which is with respect to personality rights. So when we talk about personality rights, and just to add to what Maya mentioned earlier, one of the judgments from the Delhi High Court speaks about how copyright should provide breathing space, and that it should not stifle creation, but it should encourage and enable creation. So when we talk in the perspective of deepfakes, so the first thing I'd like to address is the last point you made, that deepfakes cannot be a tool for committing crime. Very true. It cannot enable frauds, it cannot be used to defame or create derogatory content, etc. So then where is the good side of deepfakes? Is there a good side, and what is the role of IP in that? I'd like to draw from my book, which goes back to 2017, my first book, and where I talked about personality rights. And most of those case laws actually still apply pari passu for deepfakes also. The first one, a very interesting case of Samuel Keller, is not that big a celebrity as what you would think one would draw from. He was a college basketball player. In that case, the majority held in favor of the petitioner, who said his likeness had been misused in a video game without his permission. And the court held no, even though it may just be a likeness, and an animated one, you still needed to take permission when it can be directly correlated to the person. There's an interesting minority view in that, where the judge draws on Forrest Gump and the use of President Kennedy's likeness there, and says it would have merely been a box of chocolates had it not been for computer-generated imagery. So when we talk about use of CGI, or whichever name we want to give it as deepfakes or otherwise, the first issue that comes up is it can have a positive role also, not just in entertainment, but also in terms of various other uses, including education, healthcare, etc. So moving forward, or rather I would say I'll just step back a little bit to the Otto Shankar case, or what is reported as R. Rajagopal versus State, which was affirmed in the 9-judge Puttaswamy judgment, where a murder convict's right to his story being told only with his consent was upheld. Even though the story was laudatory, the court said it doesn't matter, you still needed consent. So then where does this construct of fair use come in? And that's the first provocative question I pose. Do deepfakes have a fair use exception or a defense? So you already have a lot of case laws which have evolved from the US, where case by case, the proposition has been applied to say a particular kind of CGI, depending on the mode and manner of its usage, is permissible. So on an aside, again, not necessarily CGI, but using of likeness, and because it's an interesting case to draw on, is the Lady Gaga case, where they created the Moshi monster of Lady Gugu, and she could not defend that on the basis that it was her likeness and a very common similarity in the name. But she was able to stop on the basis of her music being used for, along with this animation. So when we talk of various other celebrities who have gone both ways, one way where deep fakes have been dealt with is through use of copyright laws. So the first part of it is in terms of taking the defense of fair use to a limited extent, to that extent where you could probably either go on the basis of consent or licensing, or a direct fair use defense where it is that you say that to this extent of purpose and usage, it is permissible. Where it crosses the line is where the court says that you cannot do it. And one of the most recent takedowns is of Kim Kardashian's deepfake, where she was able to uphold the takedown on the basis of copyright, the Digital Millennium Copyright Act. And that's a very inventive way of using the Copyright Act, I would say, with respect to deepfakes. The second provocative suggestion I'd like to put forth, and it kind of ties in with what you raised earlier, is on do transformative or derivative works give a defense for deepfakes. So you talked about derivative works per se, but if you apply it to deepfakes, and that would primarily impact manipulated content. So even in the Kim Kardashian case, they used a video for Vogue and then changed the interview in a bit of a satirical manner. So the issue there was that she could not possibly go on either a personality right being violated or of her privacy, etc., being violated. The First Amendment rules are very strong in the US, and so therefore she took the innovative stand of copyright there. And that's why I posed this question. I relied very quickly on two case laws, which is of Carew versus Prince, where again the right of the artist who created merely a derivative right using multiple photographs in a different way was upheld. To a large extent, that ties in with what Maya mentioned earlier about a new artist and his creation and how AI may be reading it. And we have a very old case of R.K. Anand, which also kind of like ties in terms of the permissibility of derivative rights. I'd like to close out with two case laws from a co-panelist, Mr. Praveen Anand, the Amitabh Bachchan case and the Anil Kapoor case, where he was able to uphold the personality rights. So in one of those cases, there is a use of, in one instance, of a deep fake in a derogatory manner. So this is where the line is drawn when you talk about deep fakes. copyright or other IP laws, because even trademarks could be affected in terms of deepfakes, and also the crossing of the line into crime, the territory of crime. So where you use deepfakes to create a derogatory content or to create content, which has happened in recent times with some celebrities, where it is used for creating manipulated content for pornographic sites, for instance. That's where you cross the line and you cannot claim the defense of fair use there. That's clearly crime. So this is the last proposition I'd like to close out with, which is that you do have certain permissibility under IP laws which allow you to create, I won't use the word deepfake also, I would use computer-generated imagery or manipulated imagery, which does not harm, which does not cross the line into crime. But the minute it does cross the line, you cannot claim the benefit of copyright laws to protect you against criminal prosecution.
So I never in my wildest dreams expected to hear Otto Shankar and R.K. Anand in this discussion. But it just shows how, precedents really stand the test of time. I want to turn to you, Praveen, because I think we can keep talking about copyright. The impact of AI, generative or otherwise, on patent law and inventions, I think came out in both the keynote speeches. I think Justice Pratibha Singh spoke about Davos, which is really very, very provocative. Thaler has gone around the world trying to make a precedent on this. But I found that Nick Bostrom's reflection on, the protein folding innovation of DeepMind was extremely provocative, to say that what if AI, because of the power of AI, exhausts all the inventions in a field, and then what would happen? So I just want you to reflect on your thoughts as one of our most senior practitioners of patents through your history on what you've been doing this for many years, and then in the last 12 months there's clearly been some rapid movement, and how do you see this affect the profession?
Before I, thanks Rahul, before I start with the patents, can I just say one sentence on what Nipanya, I saw Nipanya and I've never been able to pronounce your name, and Maya, and Maya, both of them looked at me when they spoke of entertainment industry. I mean, and somebody in the past called me a joker. I think Rahul, you did. Yeah.
To be clear, I said the joker in the pack, which is the biggest compliment. You could play any role. You could be the king or you could be the one of spades.
So, I'd like to mention, other than those two cases, there's another very good example of deepfakes, which is Aradhya Bachchan. Aradhya Bachchan was the grandchild, 12-year-old girl of Amitabh Bachchan, and there were suddenly these videos which declared that she's no longer alive. And there's another one which declared that she's got cancer. All false. And when we went to court, we of course stopped them, but what was important was the judge saying that when it concerns children, then there is no excuse whatsoever, it's zero tolerance. And they must be taken down immediately. So what YouTube came and said, Google, they came and said, our policy allows us to take down for child pornography, but not for a situation like this. And the court said, rubbish. That's exactly the same harm that you're doing. Look at the harm. And so I think it's important to see what the reaction of the court when it concerns deepfakes. That's a good illustration of how harmful it can get. As regards patents, one thing I'd like to say at the outset is that patent filing, irrespective of the country, irrespective of the industry, has been rapidly increasing. WIPO's report states I'll just give one statistics. There are many ways of measuring this, but one statistics was that 367% increase from 2021 to 23 in 2 years of the patent searches on AI. So it's obviously patents are being granted and patents are being found to be very useful. Now that's a simplistic statement. Let me just analyze on what is AI and whether you look at a broad definition of 1956, the person who coined the expression artificial intelligence, John McCarthy, whether you see his broad definition or you see the narrower definition of the EU regulations, what is common is software. So software is at the heart of artificial intelligence, but also hardware, also data, data sets, and also algorithms. All of them combine to give you this creature called artificial intelligence. That's important. And therefore, all the problems of patenting that arise for software also arise for artificial intelligence. So, first and foremost, everybody's spoken about can AI be an inventor? And DABUS is a great example of two patents that were made by the artificial intelligence tool called DABUS. Stephen Thaler tried to get patents, was refused in many countries, but some of the countries came out with slightly different angles, even while refusing the patent. For example, Australia. Australia said that you could call the owner of the machine the inventor, or you could call the author of the software the inventor, or the person who owned the source code the inventor, or as a fourth example, the person who input data, the inventor. So the Australian Federal Court came up with this suggestion. USA, UK, the appeal is still pending in UK before the Supreme Court. They mostly refused in many, many countries, including India. I heard Justice Pratibha Singh say that the Indian app, something is still pending. I'm not sure of that, but I'm sure if she's checked up, it must be correct. By and large, most countries have refused. Interestingly, the two countries that granted patents were South Africa and Saudi Arabia. And one thing that I'd like to say here is, when you talk about whether AI can be an inventor, look at the suggestion made by the UK Intellectual Property Consultation 2022. They said we could say that the author includes, the inventor includes humans responsible for AI systems that generate inventions. And this is somewhat like our definition of, in the Copyright Act, of author. For a computer-generated work is the person who caused the work to be created. So it's not a big deal. Don't forget that in India, an idol in a temple can own property. A forest can file a writ petition. An animal can file a writ petition. They were all considered because according to our philosophy, everything has life. It's not the biological aspect alone. We spiritually believe that even when you exit a room from a hotel, you thank the room for allowing you to stay in it, or you thank the road for allowing you to walk on it. So, I mean, perhaps at some future point of time, a court might consider a machine that generates work to be a person, interpreting person in a very liberal sort of way. That's one thought. Then let me come to the patentability issues of AI. Those are very interesting. So one of the major hurdles is Section 3K of our Act, which, like many countries, says you prohibits software per se from being patentable. Now that, if you see a lot of AI-generated inventions being the subject of telecom. And companies like Nokia or Interdigital or Ericsson or Qualcomm, all of them have patents for AI-generated inventions. And how do they get them? Because they are able to establish that there is a technical problem which has a technical solution and a technical effect. And so something useful. It's not just use of plain software on a plain computer. You have altered the computer's working. You have achieved a useful result for man, either by way of speed or energy saving, reducing latency, or some such thing. That advantage that you've given is, if it is technical, not commercial, not financial, not legal, not ethical or aesthetic, if it is technical. And what is technical? Technical is when you solve the problem created by nature. Non-technical, when you solve the problem created by man. It's a very fundamental difference. So that deserves a patent. So a lot of patents are being granted, overcoming 3K. One more problem. Person of ordinary skill in the art. A person of ordinary skill in the art is a fictional person who reads everything in the world, but does not have intelligence. Is a person, well, it's not an inventor. It doesn't have that high level. Person of ordinary skill in the art. It's like a 10 to 5 worker. And from his eyes, you're supposed to see the prior art and assess whether the invention has non-obvious. Its non-obviousness is judged from the eyes of a poser. But in the case of a machine, don't you need a mosa, a machine of ordinary skill in the art? Because you're here looking at a highly creative object, the machine, and you're comparing that with a human inventor, and the eyes of a person of ordinary skill in the art will be so lower in intelligence that almost every AI invention will be non-obvious. So in order to correct that, you probably need to see the prior art from the eyes of a machine of ordinary level as compared to a creative machine. That's something, of course, for legislation and discussion. I don't see that having been raised anywhere, but I just thought that that's a wrong test to apply to artificial intelligence. Then, if you see, I'd also like to tell you that just a few days ago, 21st of November, the UK court granted a patent in a case called emotional perception AI versus controller controller of patents. A patent is not granted, but the court said can be granted, remanded it back to the controller to examine novelty, non-obviousness, etc. But the bar that was being spoken about, the controller said, the High Court said, no, there's no such bar. And that was a software that was used to provide recommendations of music files which would reflect the emotion of the listener. So if there was there could be a sadness or happiness or relaxation, all those would be reflected. It would determine from the tone of the listener what the mood was and give it those files. And that's been now thought to have at least the basic elements for protection through a patent. Then let me talk of the final thing, insufficiency. Insufficiency and disclosure requirements. Normally, when you have a machine which is constantly learning, what's in the black box is changing all the time. So have you as an applicant disclosed the enough, or if it alters with time, then is the statements made in the complete specification insufficient? Because that's a very interesting question, because here is not a static invention. It's an invention that is dynamic, where because of machine learning, it keeps changing. The more of data you feed in, the more it learns. And that's the reason why insufficiency could also pose as a problem. I know my time is very short, so I'll leave it to you now.
No, when I said that you were a joker in the pack, this is exactly what I meant. There's a broad sweep of perhaps everything in the intellectual property sphere that you've covered at a gallop. I want to quickly move to Abhishek, because you're right, we don't have much time, but just reflecting on many of the issues that have been discussed up until now, do we really need to rethink the way in which we're doing intellectual property legislation, intellectual property law, in the context of this new world that we're in? Praveen just talked about the fact that we thank a room before we leave. It's absolutely true. And we have a very different concept of personhood than the rest of the world does. And is it now time for India to take a sort of a lead in saying, look, we've got to rethink this concept of personhood in the context of patents and copyrights? Any thoughts on how we need to reimagine some of the things that we've taken for granted?
No, sure. So, Rahul, when I was preparing for this session, I was not sure where in the pecking order I would be placed. So I had I got the basics in place, but I was going to fine tune that depending upon what part of the intervention I was going to come in. So it's very fortuitous that I'm at the end, and you're asking me to make this summary in light of whatever comments have been made, because I think perhaps what I've prepared may come in handy for me. I will, take some snippets from whatever we've spoken about and try and weave it into the narrative that I wanted to discuss. It's interesting that among the right of publicity cases and the personality cases that Napin and I spoke about, of course, in the context of deepfakes, etc., in I think 2000 or 2001, there were a spate of these 2 or 3 cases in the Ninth Circuit, which involved a supposed likeness of this TV presenter from a series in a television series on US television called Wheel of Fortune. And this lady's name was Vanna White. Of course, no one knew about her, or no one knew her as Vanna White till such time that the case came to the courts. And the case was filed against Samsung for advertising its product with a robot, and the robot spinning the wheel. The only piece of likeness was the pearl necklace that the robot is wearing. Nevertheless, the district court and circuit court in appeal held in favor of Vanna White and preserving the right of publicity. It's my take on the fact that if it was a second circuit, it could have gone the other way, just the way that 2 circuits operate. But Justice Kozinski in both the decisions, in an en banc sort of decision, came out with a very nuanced approach to the interplay between First Amendment and your freedom of speech and expression, and to what is the extent to which IP and an extended version of IP can really sort of trump that. So this debate, interesting, and when Napin and I was speaking about it, I was reminded of that because I had the fortune of doing my LLM in the States, and this is the time when the matter had come up. So this debate about the extent to which we can expand the frontiers, or do we need to relook at the fundamentals of protection to really come up with a solution, has always been around. But, and now I sort of turn to what Maya said. When we're looking at, from a policy standpoint, when we're looking at the question that you posed to me, do we need to do things differently? Do we need to have a relook at the entire narrative of intellectual property protection? Is there a need for us to move from a natural person to a legal person, a concept that is, of course, accepted in jurisprudence, to afford this protection? Then perhaps we need to go back to the 2 aspects that intellectual property rights were created to service. One was that it is a recognition of human labor and input into adding to the Creative Commons so that subsequent generations, subsequent creators, subsequent patentees can derive from that and make something better, ultimately for the benefit of society. So if that is the point on which we are basing our creation of intellectual property rights, then we this definitely need to transcend the boundary of legal versus natural person to come to a conclusion as to whether we need to enhance to whether we need to use the current IP system to protect creativity originating from AI, and if so, do there need to be differential standards between what is applicable to a natural person and what is applicable to an AI, something which Mr. Anand also sort of mentioned about the POSA and the MOSA. Now, my point is that let's look at, and when I'm looking at these debates in the technical sphere, I always try and go back to the brick and mortar world and say, what would I do in a similar situation in the brick and mortar world? The underlying premise of copyright is originality. And world over, of course, there are differential standards of originality, but it's typically something which is accepted pretty much all over the world. It should not be copied. As an individual human being, when I am creating a work, I am also ingesting, maybe much slower than an AI, maybe much slower than a computer, but I'm ingesting all the aspects of creative elements that I have gone through over the last, I'm sorry for disclosing my age, 48 years. So when and that's something which creates an impression upon me, and that's the Creative Commons that I'm relying upon to then come out with another creative element. So the ingestion that is happening to me is happening on account of my experience. The ingestion similarly that is happening for an AI is on account of its exposure to the LLMs. So therefore, similarity in terms of conceptual aspects of the fact that there is ingestion of certain existing material. The output, of course, in a human element, what is going on in my mind and brain, the doctors have still not been able to, scientists have still not been able to figure out the manner in which it works. But in terms of the creative output is something that is purely my expression. Ideas all around, I've ingested those and I've created my expression. Similarly, in the case of AI, there would be, of course, a question, a prompt which gets the AI to generate that content, and ultimately will be on the basis of whatever it is ingested and hopefully meet the threshold of originality. And right now I'm not going on to the aspect of whether or not what is available to that AI was licensed validly, etc. I'm still at the threshold of originality. So I don't see too much of a challenge in applying the existing principles to grant protection to the content that finally comes out in the creative realm. The second aspect, and the more challenging aspect for all of us, and I think pretty much all over the world with DABUS, etc., is do we go beyond the realm of natural person to grant authorship or inventorship to a non-natural person? At least as far as what Mr. Anand mentioned in terms of computer-generated programs, and also in case of other derivative works, which is sound recordings and cinematograph films, authorship in case of sound recording cinematograph films, in fact, is recognized in a legal person, the sound recording company or the cinematograph film production company, so as to speak. So it's not as if we are bereft of any, precedents to be able to walk away from the confines of really identifying a natural person to be so. So I think, I could ramble on, but I think that really speaking, what we need to look at is not a completely different take on how to protect AI, but perhaps look at existing models, see what the challenges are, and maybe tweak them to have a differential level of threshold of originality, maybe have a differential level of protection, and perhaps the rights that flow from there, and to achieve what we, I think, want to achieve as a result.
I think I have gone well over time, largely because we have a lunch break. So I just took the liberty of denying you lunch, but I can't do that anymore. As you can see, this is a subject is as wide as it is deep. We could go on for the whole day discussing this topic. The only thing I'd like to say in conclusion is just to go back to what Maya said, and she used the word when and not if, which gets me really worried, that when AI becomes sentient. And as lawyers, that's all I care about, because if we give AI authorship and if AI is going to have copyright and patent, all I care about is when AI can retain me to actually fight on behalf of AI in a court and defend its rights. And so Maya assured me that it is not an if, but it is a when. And so I think, lawyers, as Justice Pratibha Singh said, our jobs are secure because at this point in time, humans are engaging us, but in the future, AI will. Thank you very much. You've been a wonderful audience.
Thank you to our panel for such an enlightening and informative discussion. I would now like to call upon Mr. Praveen Anand to present the concluding remarks for our session. I extend a heartfelt vote of thanks to our esteemed panel for their invaluable contributions to today's discussion. Your insights and expertise have greatly enriched our understanding of the complex relationship between AI and IP. I would now like to invite Mrs. Kavita Bhatia, Group Coordinator and Scientist G, Ministry of Electronics and IT, Government of India, to kindly felicitate all the speakers.